A cyber incident can produce several legal questions without producing one universal case. Suppose Riya's company discovers that a client database was extracted through a contractor account. The client claims substantial business loss. The company suspects deliberate misuse, but attribution and intent are still under investigation. Which route decides compensation? Is there a monetary penalty? Is there an offence for police investigation and prosecution? Can the same facts support more than one route? Episode 11 answers by separating contravention, compensation, penalty, and offence. The Information Technology Act contains civil or regulatory consequences in Chapter 9 and criminal offences in Chapter 11. Some conduct can move from the Section 43 contravention framework into Section 66, when the additional dishonest or fraudulent mental element is present. Other provisions create their own penalties or offences. The correct forum therefore depends on the exact provision, the relief sought, the amount, and the procedural stage. Section 46 establishes adjudicating officers for contraventions that render a person liable to pay penalty or compensation. It also draws a 5-crore line for claims for damage, with larger claims going to the competent court. Appeals from the controller or adjudicating officer go to the appellate tribunal, whose IT Act jurisdiction is exercised by TDSAT, and Section 62 provides a further appeal to the High Court. We will also distinguish compounding of contraventions under Section 63 from compounding of offences under Section 77A, then examine recovery and confiscation. The purpose is not to choose a forum for a real dispute. That requires fact-specific legal advice. The purpose is to build a route map. Riya's incident should not be labelled civil or criminal as if only one adjective may survive. The evidence can support parallel questions, but each question must carry its own elements, decision-maker and remedy. Legal route begins with elements, not the emotional seriousness of the loss. Section 43 addresses specified acts involving a computer system, or network when done without permission, including forms of access, copying, introducing contaminants, damage, disruption, denial, and assistance, with compensation consequences. Section 66 makes the Section 43 acts criminal when they are done dishonestly or fraudulently. That additional mental element is not decorative. Evidence that a database was copied without permission may support a Section 43 contravention while the investigation into dishonest or fraudulent intent continues. Conversely, evidence of a deliberate scheme may support criminal analysis, but compensation still requires proof of the relevant loss and causal connection. This distinction protects both sides of the process. It prevents a claimant from assuming that any breach proves criminal guilt, and it prevents a suspected offence from making the victim's compensable loss invisible. Build a matrix with one row per legal element. What act occurred? Was permission absent or exceeded? Which computer resource was involved? What damage or loss followed? How is causation shown? Which evidence supports dishonest or fraudulent intent? Who can be attributed to the act? Riya's team finds that the contractor account downloaded records outside the approved support window. The identity log proves account use, not yet the human user. A large client loss estimate arrives, but it combines incident response costs, lost contracts, reputational impact, and speculative future business. Those categories need evidence and legal relevance, not one round number. Meanwhile, a message suggests that someone intended to sell the data. Its authenticity and context must be proved before it carries criminal weight. The remedy analysis can move while attribution develops, but conclusions should remain scoped. Section 43 and Section 66 show why bare facts do not choose a route by themselves. The same technical event becomes legally intelligible only when permission, consequence, and mental element are analysed separately. Section 46 authorises adjudicating officers to decide whether a person has committed a contravention of the Act or of a rule, regulation, direction, or order made under it that renders the person liable to pay penalty or compensation. The central government appoints an officer of the required rank and qualifications, and the inquiry follows the prescribed framework. The person proceeded against must receive a reasonable opportunity to make a representation. If the adjudicating officer is satisfied that the contravention occurred, the officer may impose the penalty or award compensation in accordance with the relevant provision. The current wording matters. The Jan Vishwas amendments, in force for the IT Act changes from 30 November 2023, replaced the narrower phrase under this chapter with under this Act and made related textual changes. That is one reason older notes can misstate the present reach of adjudication. Section 46 also gives the adjudicating officer specified civil court powers for the inquiry and execution context. Those powers do not transform the process into an ordinary civil suit. They support evidence, attendance, documents, and enforceability within the statutory scheme. For Riya's incident, the claimant must identify the contravention said to trigger compensation or penalty. A narrative that the incident was bad is not a pleading of elements. The respondent must know the case to answer. Relevant material may include access permissions, system records, contracts, forensic reports, loss evidence, and witness statements. The adjudicator is not a substitute for criminal trial, and a police investigation is not a substitute for proving the compensation claim. The two processes may use overlapping evidence while answering different questions. Before filing or responding, verify the current provision, the appointed adjudicating officer with territorial or subject jurisdiction, the applicable rules and amendment, the relief sought, and the amount. This episode explains the architecture. Actual forum strategy. Limitation and pleadings require professional advice based on the current notification and local facts. Section 46, 1a, draws a monetary boundary. The adjudicating officer exercises jurisdiction in matters where the claim for damage does not exceed 5 crore rupees. The competent court has jurisdiction where the claim exceeds 5 crore rupees. The Jan Vishwas amendment removed the words injury or from this subsection, so current consolidated text should be used. The 5 crore figure is not a measure of whether an incident is serious. It is a forum rule connected to the claim. That makes valuation a jurisdiction fact rather than a publicity number. List the heads of damage and the evidence for each. Direct response expenditure, system restoration, interruption, contractual liability, and lost business may raise different questions of proof, remoteness, mitigation, and duplication. A claimant should not inflate a speculative estimate to reach a preferred forum, and should not artificially split one cause to stay below the line. A respondent should not assume that uncertainty means zero loss. Expert accounting or technical evidence may be needed, but the expert must expose method and assumptions. Riya's client initially states a 7 crore loss. Review shows that 2 crore is a possible future renewal that had not been agreed, while the remaining amounts include documented restoration cost and cancelled orders. Whether the claim exceeds 5 crore is a legal and evidentiary issue, not arithmetic performed in a meeting. Counsel would examine the cause of action, legally recoverable heads, evidence, and any related claims before choosing the forum. The 5 crore rule also does not decide criminal jurisdiction. A modest compensation claim can accompany serious alleged criminal conduct, and a large civil claim does not prove an offence. In an exam answer, write the route precisely. Adjudicating officer for a claim for damage not exceeding 5 crore. Competent court for a claim exceeding 5 crore. Separate criminal process where an offence is alleged. In practice, verify the current text and filing requirements before relying on the threshold. The information technology, qualification and experience of adjudicating officers, and manner of holding inquiry. Rules 2003, as amended, support the Section 46 inquiry. At a high level, expect a complaint or initiating material, scrutiny of the alleged contravention, notice to the person concerned, an opportunity to respond, production of relevant evidence, hearing where required, and an order. Do not reduce natural justice to a ceremonial email. The respondent must understand the material allegation and have a reasonable chance to answer it. The adjudicating officer can use civil court-like powers specified by the Act, including attendance and production of documents or electronic records. The process is not bound to mimic every step of an ordinary suit, but fairness, relevance, and a reasoned link between evidence and conclusion remain essential. Digital material requires the same discipline developed in Episode 8. A dashboard screenshot may show an alert. The native log and its custodian explain source. Hashes and acquisition records support integrity. Identity and access records explain what an account could do. Contracts and authorization records explain permission. Witnesses and system context address attribution. Financial documents address loss. Expert reports must state the method and limitations rather than announcing that cyber evidence proves everything. Riya's company receives notice relying on an exported spreadsheet of database queries. The export omits time zone and filtering criteria. Instead of merely denying the claim, the response obtains the native audit records through controlled collection, explains the server clock, identifies gaps, and provides the contractor's approved task list. The claimant produces cancellation correspondence and response invoices. The adjudicator can then test conduct, permission, causation, and quantum on a fuller record. Parties should also preserve privilege and confidentiality appropriately. Filing sensitive system data without safeguards can create new risk. The rules should be read in their current form before any real filing. Here, the transferable skill is to organise evidence by legal element and procedural purpose, not by whichever file was easiest to print. Section 47 directs the adjudicating officer to have due regard to 3 factors while deciding the quantum of compensation: the amount of gain of unfair advantage, wherever quantifiable, made as a result of the default, the amount of loss caused to any person, and the repetitive nature of the default. The factors pull the analysis beyond a single invoice. Unfair advantage may appear in avoided cost, illicit commercial benefit, or another quantifiable gain, depending on the contravention. Loss must be caused by the default, not merely occur in the same period. Repetition can distinguish an isolated failure from a pattern that continued after warning. These are statutory factors, not a formula that mechanically adds 3 numbers. Evidence and the relevant provision still control the available result. Riya's claimant attributes all quarterly revenue decline to the database incident. Market data shows that much of the decline began earlier. At the same time, the respondent initially calls the event isolated, but earlier access reviews contain 3 warnings about the same contractor account. Both sides need a more careful account. The claimant can connect specific cancelled orders, response costs, and customer communications to the incident while acknowledging uncertainty. The respondent can show mitigation steps and challenge unsupported categories, but repetition evidence may weigh against a claim of pure accident. A credible expert distinguishes observed amounts from models, provides ranges where appropriate, and discloses assumptions. It also avoids counting the same loss twice under different labels. The adjudicator's task is not to express moral outrage in rupees. It is to connect the statutory contravention, its consequences, and the Section 47 factors to an order. In an educational answer, state all 3 factors. In practical preparation, create a schedule with each claimed item, date, source document, causal explanation, amount, uncertainty, and response. That schedule makes disagreement visible and helps the tribunal or court see which parts are proved, which are contested, and which are speculative. Chapter 10 still uses the generic term appellate tribunal in the current IT Act. Following the 2017 tribunal rationalisation, the Telecom Dispute Settlement and Appellate Tribunal, or TDSAT, exercises the jurisdiction, powers and authority conferred on the appellate tribunal under the IT Act. Section 57 allows a person aggrieved by an order of the controller or an adjudicating officer to appeal to the appellate tribunal having jurisdiction. The ordinary filing period is 45 days from receipt of the order, in the prescribed form and with the prescribed fee. The tribunal may entertain a later appeal if sufficient cause prevented timely filing. That discretion is not a reason to let the deadline pass casually. Record the date of receipt, obtain the complete order, and start the limitation analysis immediately. Section 57 also says that no appeal lies from an adjudicating officer's order made with the consent of the parties. A consent resolution therefore carries procedural consequences that should be understood before agreement. On an appeal, the tribunal gives the parties an opportunity of being heard and may confirm, modify, or set aside the order. The Act states an endeavour to dispose of the appeal as expeditiously as possible, with a 6-month target. Riya's company receives an adverse order and initially asks the High Court to review it directly. The statutory route ordinarily points first to the appellate tribunal under Section 57, then to the High Court under Section 62. Counsel would examine exceptions and writ jurisdiction in the actual facts, but a basic route map should not skip TDSAT. An appeal is also not a fresh opportunity to ignore the evidentiary record. Identify the error. Interpretation, jurisdiction, procedure, fact assessment, causation or quantum. Preserve the record and comply with procedural requirements. The institutional label is easy to get wrong because older material says Cyber Appellate Tribunal. Current teaching should say Appellate Tribunal under the IT Act, exercised by TDSAT. Section 58 says the Appellate Tribunal is not bound by the Code of Civil Procedure, but is guided by natural justice, and may regulate its own procedure within the Act and rules. For its functions, it has specified powers of a civil court, including summoning and enforcing attendance, requiring discovery and production of documents or electronic records, receiving affidavit evidence, issuing commissions, reviewing decisions, and dealing with default or ex parte situations. Section 59 recognises legal representation. Section 60 applies the Limitation Act as far as may be to an appeal. Section 61 bars civil court jurisdiction over matters the adjudicating officer or appellate tribunal is empowered to determine and restricts injunctions against action under the Act's powers. Then Section 62 provides the next appellate step. A person aggrieved by a decision or order of the appellate tribunal may appeal to the High Court within 60 days of communication on a question of fact or law arising from the order. If sufficient cause prevented filing, the High Court may allow a further period not exceeding 60 days. The words fact or law distinguish this provision from appellate statutes that restrict further appeal to a question of law alone. They do not eliminate procedure, preservation of objections, or standards of appellate review. Riya's company believes the tribunal treated an account identifier as conclusive proof of the employee's identity. The appeal would need to show from the record why that inference was unsupported and material to the result. If the company failed to produce readily available identity logs without explanation, the appellate posture may be different. Deadlines also run from communication of the relevant order, so receipt records matter. The practical timeline is therefore: obtain and preserve the order, calculate limitation, identify appealable error, secure the record, follow the prescribed form, and seek specialist advice. Natural justice gives a fair opportunity. It does not guarantee that omitted evidence can always be repaired later. Section 63 deals with compounding of contraventions, which is different from compounding criminal offences. A contravention under the Act may be compounded before or after adjudication proceedings begin by the controller, an officer specially authorised by the controller, or the adjudicating officer, as applicable, subject to specified conditions. The compounding sum cannot exceed the maximum penalty that may be imposed for the contravention. Once the contravention is compounded, no proceeding or further proceeding is taken against the person for that contravention, but the route is not available where the person commits the same or a similar contravention within 3 years from the date on which the first contravention was compounded. A second or later contravention after that 3-year period is treated as a first contravention for this purpose. Compounding is not a word for informal settlement of every cyber dispute. It is a statutory mechanism with authority, eligibility, conditions, and consequences. It should also be distinguished from compensation to an affected person. Depending on the provision and order, resolving the regulatory contravention may not answer every private contractual or civil issue. Riya's company considers compounding a reporting-related contravention. Before deciding, it must identify the exact provision, maximum penalty, authorised decision-maker, any prior similar compounding, and the effect on related proceedings. It should not describe the process as buying innocence or assume that payment deletes the factual event. Remediation, disclosure obligations, contractual rights, and criminal allegations may remain distinct. A compliance programme should record the underlying cause and prevent recurrence. Otherwise, the 3-year rule may become significant. In an exam, write the statutory limit and repeat default condition. In practice, obtain current legal advice because the terms, authority, and interaction with other claims are consequential. The central distinction is simple. Section 63 compounds a contravention in the adjudication framework. Section 77A, discussed next, addresses compounding of offences by a competent court and contains different exclusions. Section 77A allows a court of competent jurisdiction to compound IT Act offences other than offences for which life imprisonment or a term exceeding 3 years is provided. It excludes cases where a previous conviction exposes the accused to enhanced or different punishment. It also says the court shall not compound an offence affecting the socio-economic conditions of the country or committed against a child below 18 or a woman. The accused applies in the court where the offence is pending, and the criminal procedure compounding provisions referenced by the section apply. This is a judicial route for offences, not the controller or adjudicating officer's Section 63 route for contraventions. Section 77B then supplies a classification rule that is frequently paraphrased badly. Notwithstanding the Criminal Procedure Code, an offence punishable with imprisonment of 3 years and above is cognizable, while an offence punishable with imprisonment of 3 years is bailable. The exact maximum term in the charged provision therefore matters. Do not say that all IT Act offences are bailable, or that every cognizable offence is non-bailable. Cognizability and bailability are different classifications. Other procedural law, current criminal codes, and case-specific orders also require professional analysis. In Riya's matter, investigators consider a provision carrying up to 3 years. The team should identify the exact charge rather than derive procedure from the general label cybercrime. If compounding is discussed, counsel must assess the statutory exclusions, victim category, prior conviction, and alleged socio-economic effect. The company cannot privately promise that a criminal case will disappear, nor should a settlement negotiation interfere with evidence preservation or reporting duties. The educational roadmap is Section 63 for statutory contraventions through the specified regulatory actors, Section 77A for eligible offences through the competent court, Section 77B for cognizable and bailable classification by punishment. Similar vocabulary does not mean identical procedure. An IT Act outcome can extend beyond a finding and a number on paper. Section 64 addresses recovery of penalty or compensation where payment is not made, treating the amount through the statutory recovery mechanism. Section 76 permits confiscation of a computer, computer system, device, data, or other matter connected with contravention of the Act, rules, orders, or regulations, subject to the statutory framework and protection for a person who is not responsible and has taken the required precautions. Section 77 makes clear that compensation, penalties, or confiscation under the Act do not interfere with the award of compensation or imposition of another penalty or punishment under another law. The phrase does not authorise double recovery without legal basis. It means the IT Act's consequences do not automatically displace other lawful consequences, analyse overlap, cause, statutory bars, and credit for amounts with counsel. Confiscation also requires a nexus. A device found near an incident is not automatically an instrument of contravention, and ownership is not guilt. Shared, leased, and employer-owned devices create interests that must be considered through the legal procedure. Riya's contractor used a company laptop later recovered from another person. The investigation images the device under lawful authority and preserves chain of custody. Whether the physical laptop should be confiscated is distinct from whether data on it is evidence, whether the company owns it, and whether the person possessing it committed an offence. Meanwhile, an adjudication award is not self-executing in the everyday sense. The recovery route matters if payment is not made. A remedy table can list each consequence, legal source, decision maker, target, proof, and enforcement method. That table prevents a common mistake, treating compensation, penalty, confiscation, and criminal punishment as four names for the same thing. They protect different interests and operate through different powers, even when one incident supplies the factual background. Close every remedy analysis with a route checklist. First, identify the exact current provision and whether it creates compensation, a monetary penalty, an offence, or more than one consequence. Second, list the elements and evidence for each without importing a criminal mental element into a civil claim or assuming that a contravention proves guilt. Third, state the relief sought and support every category of loss with causation and documents. Fourth, calculate the claim honestly. Up to 5-crore in a claim for damage points to the adjudicating officer. A claim exceeding 5-crore points to the competent court. Fifth, verify the appointed adjudicator, current rules and territorial or subject jurisdiction. Sixth, prepare for notice, response, electronic evidence, and hearing under the prescribed inquiry. Seventh, address Section 47's unfair gain, caused loss and repetition factors. Eighth, record receipt of every order. Ninth, calculate the 45-day Section 57 appeal period to the appellate tribunal function exercised by TDSAT and remember the consent order limit. 10th, if necessary, calculate the Section 62 High Court period of 60 days with only the statutory further period available for sufficient cause. 11th, distinguish compounding of contraventions under Section 63 from court compounding of eligible offences under Section 77A. 12th, analyse recovery, confiscation, and other lawful consequences separately. In Riya's fictional matter, the client refines its loss evidence, the parties preserve the contractor account records, and criminal attribution remains separate from the compensation route. Nothing in the scenario accuses a real person. The final lesson is that forum is part of substance. A correct section filed in the wrong route, or an appeal begun after limitation, can change the practical result. Episode 12 follows responsibility inside organisations. We will examine the post-Jan Vishwas residual provisions, abetment under Section 84B, attempt under Section 84C, company liability under Section 85, the due diligence defence, and the difference between being senior and being legally connected to the contravention.